A three-judge bench comprising Justices David Wajanja, Christine Meoli, and Rollins Mugambi today ordered the government to cease the collection of the housing levy holding. It contravenes the Constitution. Joining me to have this conversation is Wanjala Opora, a lawyer and advocate of the High Court. Keep your questions and comments coming in through our SMS line 21144 and GBS TV Africa on all our social media handles. Good evening, Mr. Wanjala. How are you?
Good evening, and thank you for the invitation. Happy to be here back again, just to discuss this very important subject.
Thank you so much. And now to just straight away begin our conversation tonight on the ruling of the Finance Act 2023. Now we saw today the court declare some sections of it unconstitutional, that is including the housing levy. So could you please break this down for us and perhaps put the ruling into perspective?
Very well, thank you. So I think the issue which was before the judges of the High Court, that is Meoli, Mugambi, and Majanja, it was with respect to the constitutionality of the entire Finance Act. And so the judges made certain findings. They found that partially the Finance Act was constitutional, that is with respect to the Betting Act, the winnings around that. However, the judges were also very clear that a segment thereof was actually and is unconstitutional, and that is with respect to the Affordable Housing Levy and the provision in relation to the Statutory Instrument Act. And so the judges made a determination around this, and I think this is something which Kenyans were eager and were waiting for. And so the determination of the same was timely, and we are glad that the court has pronounced itself on this particular issue around the constitutionality of various provisions of the Finance Act.
Thank you. And now going into the details, we saw one of the lawyers representing the Azimio One Kenya Alliance in his submission to the court termed the Declaration of Invalidity, quoting Article 23, that is authority of courts to uphold and enforce Bill of Rights. And of course, it took Section 3 in any proceedings brought under Article 22, a court may grant appropriate relief, including we have one, a declaration of invalidity of any law that denies, violates, infringes, or threatens a right or fundamental freedom in the Bill of Rights and is not justified under Article 24. How to translate this article of the Constitution?
Yes, so I think the entire Article 23 of the Constitution is concerned with the reliefs and remedies that a High Court can grant where one has made an application in connection with breach of constitutional rights. And so the specific article that you are referring to, that is sub-article D, is with respect to declaration of invalidity of a section of them. And so the court is being called upon to say that, look, this particular Finance Act has breached various constitutional provisions. And that is why the advocate for Azimio, my good friend, Mr. Binga, made reference heavily on the provisions of Article 23, sub-article D of the Constitution with respect to the right to declare that something is actually unconstitutional. And so I think it's a good thing that we have the Constitution there, and it's able to help us enforce the rights that as and when you feel that we are actually agreed in that respect.
And moving on, we'll take a look at some of the court findings. They did say the house levy was discriminatory since it targeted employed Kenyans and excluded other categories of income. And of course, this is not a new situation. We saw Kenyans and public servants reject the levy way before. Wakili, how did we miss this in the first petition?
Yes, I think, and thank you for asking this, because I think most Kenyans are also asking the same thing. You will recall that the first petition is, this judgment is actually determining that particular petition filed by Okiya Omtata and 6 others. Now, the court could not have granted those orders the way it has made them right now, because earlier on, her ladyship, Lady Justice Sunday, granted interim orders suspending the bill. Then it was a bill. But the judges have now made substantive orders in a judgment dealing with this particular issue. And let me just say this. I think the judge is actually saying, one, look, you cannot discriminate in taxation, because Article 201, sub-article B, says that taxation must be fair. And so you can't just tax with a lot of discrimination Explain to me why you are asking whoever is working as civil servants, whoever is employed, to be the only person contributing to a house that will be enjoyed by both those who are employed and unemployed. There must be some fairness. So it is saying that actually, whereas Parliament has powers to pass legislation, it must be fair. It should not be seen to be favoring the unemployed over the employed. And I think that's actually where the problem is, because you have a government where you are saying that, you know, we want to build houses for those who are working, to build houses for those who are not actually working. And so there's need for fairness. That's the first thing that actually the judge brings out with respect to discrimination. And finally, the judge is saying that we do not really have outlined provision as to how we shall deal with the affordable housing levy. Who will benefit? What happens if I have a house in Kiganjo, let's say somewhere in Meru? I am living in Meru. What happens to my house? I have a house already. What happens if I retire? Will I be built a house? So the issues which Kenyans are asking, yet you have a levy being rolled out, you have Kenyans contributing, without necessarily giving us an opportunity to understand how will the levy operate. They are just saying, look, can we have proper legal framework before we begin implementing an act of parliament with respect to taxation of affordable housing levy?
Thank you. And now we have seen that it has been ruled unconstitutional, the housing levy. And how do Kenyans go around that? Are they able to get their money back, from your view as a lawyer? Is that possible?
Yeah, I think most Kenyans are on the same. I mean, a refund is our money, you know, and I will understand. But let me put two things into context. You will recall that the learned judges of the High Court, they have granted an interim order suspending the implementation of their judgment up to 10th day of January 2024. It means that actually in the interim, we'll be making contribution, yeah, until that date comes. The whole idea is just to give them the leave for you to appeal. But in the event that after 10th, we then have to comply, the government has to comply, and perhaps there's no appeal to the Court of Appeal and there's no stay order from Court of Appeal, then you are actually entitled to a refund. Under the provision of Section 47A of the Tax Procedures Act, this was a section which I participated in drafting myself. And one of the things we're thinking is we didn't have provision with respect to refund of taxes paid in error. And so this section actually captures you very well. That you can actually apply for refund of taxes that you paid in error, such as this one here. If you apply for such refund, you will ultimately get the money refunded to you. The only problem is this country is you'll have to fight the government for very long for them to refund you. But actually, you are entitled to refund. Thank you.
Thank you. And now, coming January, and the ruling is supposed to happen, what are your predicaments? What should we be expecting?
Yes, definitely. I mean, it is an issue of balancing around that, because you will recall that the petitioner, Honorable Senator Okiya Omtata, had filed a petition. He might not be content with all the aspects of the judgment. For example, the judges are saying that they find that the issue of vetting is actually constitutional, the issue of taxation of insurance under the VAT Act is actually constitutional, the issue of digital tax is, so a number of those actually have been found to be constitutional. Now the implication is, if the petitioner, Okiya Omtata and the group, feel aggrieved partially with some of the elements of the judgment of the High Court, then they can also file what we call a cross appeal. We are also foreseeing there's a possibility that the government might want to appeal against this decision at the Court of Appeal. Now, should they appeal, they will first of all seek to appeal against the entire judgment, or at least partially against the aspects of affordable housing levy that have been declared unconstitutional. Now, in their appeal, they will seek for what we call an application for stay, where they will want that the order that was granted by Justice Majanja, Meuli, and Mugambi today, up to 10th of January, that order actually extends even beyond 10th of January. That's something that I foresee them asking. And the court might decide. We might decide to grant the order. We might as well decide not to grant the order. So it's something which we want, it's a wait and see as to how the Court of Appeal will behave with this. Now, if the Court of Appeal grants the order of stay, of course, we continue paying taxes as if that judgment has not taken effect. If the Court of Appeal refuses to grant the orders of stay, then the government needs to refund you the money, And number two, you will not be contributing affordable housing levy anymore. However, the other taxes, which the judges of the High Court found to be constitutional, will continue to apply. And so it's a matter of wait and see, and let us wait and see what the judiciary will do about this. And finally, the government also has what you call legislative measures. Remember that the judges have an issue with the manner in which the affordable housing levy is being dealt with respect to one, how are you accounting for this money? Who is benefiting, among other factors? These are things which we foresee. The government might come with a new legislation to try and cure some of these loopholes and lacuna in the law. And so it's a matter of wait and see. But I think it's a very interesting time for Kenya and a very interesting judgment, and it has a huge implication in terms of upholding the provisions of the Constitution of Kenya.
Looking at the chances and supposing that the housing levy is scrapped off from the Finance Act 2023, what financial implications will that have on the government?
Yes, I think one thing that the government is going to bring out, definitely at the Court of Appeal, they'll say that actually, if we don't grant us an order suspending the implementation of the judgment of the High Court with respect to affordable housing levy, we will have a problem with running the government. We'll be cash trapped, and we'll be struggling to run an economy. But I think it's an issue of, look, we are only suspending the affordable housing levy. You still have other provisions of the Act which are constitutional, and you can continue collecting money. So it's an issue for the lawyers acting for the petitioner, Okiya Omtata among others, to persuade the court that you should not continue extending this stay, because in an event you're actually benefiting from the other provision of the Act. It's only the affordable housing levy that the court has said is unconstitutional. It's a matter of government to try and make a case around that, but I think it's a matter for the Court of Appeal to decide and to really look at the merits and the demerits of those kind of arguments generally.
And now to conclude our conversation tonight, perhaps you can take us, what are some of the options that are available for the government as well as the other petitioners going forward?
Yes, so I think the options which are available to the government, one is the government might want to go what we call the legislative framework. One thing that Lady Justice Meole was saying in the judgment was that, one, you cannot ask the court to declare an act of parliament to be unconstitutional merely because there's some hardship that you think is unfair, that you think the tax is excess. No one likes paying taxes. And so you cannot just ask them because of that. And so in light of that, one of the things that actually we suspect and we foresee happening is that, you might want to have a government perhaps saying, let's revise the procedure as to how we brought the affordable housing levy. We want to bring it as a specific act of parliament. We want to create a fund to manage it. We want to create a good system before we can roll it out. So one is legislation. Number two, the government might want to appeal against this. And of course, you might expect a cross appeal. So these are things which we expect to happen, but we will be looking at this and just monitoring how this turns out and unfolds. And then, of course, based on that, we will be able to know, what trajectory is this case taking. But I think it's a very interesting case and a good time living in Kenya, where we can uphold the provisions of our constitution.
Thank you so much, Wakili, for your wonderful insights. And of course, there's a lot to talk about when it comes to the ruling of the Finance Act 2023. But sadly, time is not on our side. So perhaps you can give us briefly your parting shot in a minute.
Okay. Thank you very well. Thank you also for the invitation. I think it was a good session. And mine just to say that I think Kenyans must learn that the court cannot assist you much. Can only look at whether whatever has been passed is properly law or not. It is the National Assembly and generally the legislature that can save Kenyans from some of this overtaxation. And so it is important that actually we ask members of parliament to come up with good measures that help Kenyans in mitigating the harsh economic realities. We hope that at least as we vote for members of parliament, as we vote for the government, we take into account that actually it is the MPs who determine everything. The court can only save you to some extent. Thank you so much and wishing you all a good